All right, council member, we are live on YouTube and you may begin when you're ready.
Thank you. Good afternoon. I'm Robert White, council member at large and chair of the Committee on Government Operations and Facilities. Today is Wednesday, July 14th, 2021, and we are meeting remotely via the Zoom teleconferencing platform. The time is now 12:30 p.m. and I'm calling to order this public hearing of the committee. As I start out, let me apologize for starting late. I was in back-to-back meetings that got backlogged very early, so I do apologize for the delay. There's one bill on the agenda of this hearing today, B24-129, the Inspector General Enhancement Act of 2021. This legislation was introduced by Chairman Mendelson at the request of the Inspector General on March 1st, 2021, and referred to this committee the following day for review. Notice of this hearing was initially filed on May 10th, and that notice was updated on June 1st. Broadly speaking, the purpose of this legislation is to formally recognize the Office of the Inspector General's criminal investigators as law enforcement officers. Among the authorities the Inspector General has requested to help it accomplish its independent criminal investigation mission include the authority to carry less lethal weapons inside or outside of the district, lethal weapons as well, to make arrests based on probable cause, to apply for and execute arrest warrants, and to enter into agreements with federal partners. The Inspector General argues that these authorities are necessary for the office to meet its statutory responsibility to independently investigate crimes under its jurisdiction, like fraud against the district, construction, bribery, and patient abuse, neglect, and financial exploitation against district Medicaid beneficiaries. That investigation of these crimes can take the office's criminal investigators across the city and the country and put them at risk, and that the lack of recognition of the IG's criminal investigators as law enforcement officers and recent legal interpretations of its authority have resulted in increasing challenges to the IG's ability to accomplish its mission. The authority sought by the IG is similar to that currently provided to federal inspectors general, arson investigators, animal control officers, Office of Tax and Revenue special agents, and others. As we consider this request to expand law enforcement authority, we have to do so in the context of a community in the process of broadly reevaluating the role of law enforcement. To that end, we should not expand law enforcement authorities unless they are clearly necessary. The purpose of today's hearing is to evaluate the Inspector General's request for additional authority and to begin to determine what guardrails, if any, would be needed if this bill passes. Before we start testimony from the Inspector General, I want to quickly lay out the ground rules for our witnesses. We actually don't have any public witnesses signed up to testify, so we will not need that aspect. So at that, let me call up our only witness, Inspector General Daniel Lucas, the district's Inspector General. General Lucas, welcome.
Good afternoon, Chairperson White. How are you?
Doing well, doing well. Good to have you. If you're able to turn up your volume a little bit, that would be helpful.
Okay.
And will anyone else be joining you?
Yes.
Okay. Well, then it is, as you know, the practice of this committee to put all of our government witnesses under oath. So I would ask everyone who is or may be testifying to come on screen momentarily.
How's that?
That's a little bit better. Thank you.
All right, good. Yes, joining me is Ms. Karen Branson and Mr. LeVan Griffith.
Wonderful. We will have them join us so I can put everyone under oath at the same time. We're waiting for one additional person, correct?
Yes.
Okay.
Good.
LeVan will just have to do voice.
Okay, Mr. Griffith's camera is not working, but his mic should be, if that's okay with you.
Yes. Can you hear me and confirm that you're there?
LeVan?
Yes.
Perfect.
Yes.
Thank you. All right. I will ask everyone to raise your right hand. Do you swear or affirm? Let's figure this out. All right, we'll stay on mute for now. Do you swear or affirm under penalty of perjury that the testimony you are about to provide to the Committee on Government Operations and Facilities is the truth, the whole truth, and nothing but the truth? Okay, I saw you both say I do. Well, welcome. Good to have you with us, and you can begin your testimony when you're ready, General Lucas.
Good afternoon, Chairperson White and members of the committee. I am Daniel W. Lucas, Inspector General for the District of Columbia. I am pleased to virtually appear at the committee's public hearing on Bill 24-0129, the Inspector General Enhancement Act of 2021, hereafter referred to as the bill. The purpose of this bill is to close the gap between our criminal investigation legislative mandate and our criminal investigation legal authority. In other words, this bill seeks to remedy the situation where the law prevents OIG criminal investigators from doing what the law requires them to do. Joining me to assist during this testimony are Karen Branson, the OIG's General Counsel, and LeVan Griffith, the Director of OIG's Medicaid Fraud Control Unit, or MAFUCU. Ms. Branson has served as the OIG's General Counsel since December 2000 and brings a historical perspective as she has seen how the agency's investigative statutory framework has evolved. Mr. Griffith, the OIG's Director of the MAFUCU, has 30 years of experience as a criminal investigator and criminal investigator executive. Mr. Griffith has been with the OIG since 2017, following his retirement from the National Passenger Railroad Association, or Amtrak, OIG, as their Assistant Inspector General for Investigations, or the head of their investigations department. During his tenure with Amtrak, in addition to leading Amtrak's criminal investigative mission, Mr. Griffith successfully led efforts to improve Amtrak's law enforcement statutory framework. First, I think it's essential to explain the evolution of the OIG's work and corresponding authorities that has brought us to this current state, a state which is akin to asking this body to provide oversight of district agencies without the authority to hold oversight hearings. Our criminal investigation mission was codified in 1995 when Congress added the requirement for the OIG to promptly refer suspected violations of district or federal law to the United States Attorney General. This new mandate made it clear that the OIG was responsible for conducting criminal investigations. Investigating alleged crimes against the district's programs and operations introduced certain risks to the OIG investigators, namely their safety and the safety of others as they execute their mission. To increase OIG criminal investigators' safety and increase the effectiveness of OIG criminal investigations, this body codified into law in 1999 that OIG investigators could carry a firearm within the District of Columbia or a district government facility located outside of the district, make an arrest without a warrant if the OIG investigator has probable cause to believe a felony violation is being committed in his or her presence, and the investigator is engaged in the performance of his or her official duties within a district or a district government facility located outside of the district, and to serve as an affiant for, apply to an appropriate judicial officer for, and execute a search warrant for the search of premises or the seizure of evidence if the warrant is under the authority of the District of Columbia or the United States upon probable cause. Over time, while executing our criminal investigation mandate, my predecessors began to identify a gap between our criminal investigation legislative mandate and our criminal investigation legal authorities. Consequently, in 2001, the OIG sought to close the gap and provide for the ability to execute arrest warrants with probable cause and add OIG criminal investigators to the district's definition of law enforcement officers. For reasons unclear to me, this legislation did not make it beyond its initial public hearing, so the gap persisted. Once I was appointed as the Inspector General in November 2014, in an attempt to maintain fidelity to the criminal investigative mandate, I also recognized the gap identified by my predecessors. We sought guidance from the Office of the Attorney General, which confirmed our analysis. Therefore, in 2016, we proposed legislation to close the gap akin to the OIG's 2001 efforts, namely the ability to seek and execute arrest warrants with probable cause and to add OIG criminal investigators to the district's definition of law enforcement officers. The former Committee on Finance and Revenue held a roundtable on this proposed legislation in October 2016. In January 2017, the OIG was moved to the Committee on Government Operations. The OIG briefed the gap to the committee chair. However, the legislation was not reintroduced. Since 2016, we have instituted policies and procedures designed to mitigate the impact of the gap between our criminal investigation legislative mandate and our criminal investigation legal authorities. Our policies and procedures and the corresponding limitations placed on our investigative tasks caused our partners conducting joint investigations with us to raise concerns with our ability to execute the scope of our criminal investigative mandate. Internally, our criminal investigators also raised concerns about their ability to safely conduct criminal investigations. Collectively, these concerns were aimed at ensuring the OIG could independently and, when appropriate, respond as co-equal partners to investigate crimes against district programs and operations, rather than be a liability in the event that routine investigative activities escalated into hostile situations, both in and outside of the district. Consequently, with the additional concerns raised by our partners and staff, I took another review of our enabling legislation and other relevant statutory authorities. Our conclusion, reinforced by OIG opinion, determined that our statutory criminal investigative framework gap was even wider than previously thought. This conclusion caused us to further restrict our criminal investigative activities. To date, we have exhausted all potential solutions within my span of authority to mitigate the impact of the gap. Now, I would like to walk the committee through what a criminal investigation looks like and examples of authorities provided to investigators to execute certain investigative tasks. In practical terms, investigations of alleged violations of federal or district law require criminal investigations to perform specific tasks to be executed by criminal investigators. These tasks include issuing rights advisements, interviewing complainants and witnesses, conducting surveillance, serving subpoenas, executing search warrants and collecting evidence, testifying before a grand jury, arresting individuals pursuant to a criminal complaint or grand jury indictment, and preparing cases for prosecution and liaising with prosecutors in preparation for and during a trial. Criminal investigators must execute these tasks while ensuring the public's safety as well as their own. Further, criminal investigators must execute these tasks while protecting an individual's constitutional rights, in addition to preserving the sanctity of the criminal investigation and the potential for prosecution. Now let's discuss statutory authorities to perform criminal investigative functions. Statutory authorities permit or restrict the ability of criminal investigators to act. They set the boundaries within which they may execute their criminal investigative mandate. What follows is an outline of authorities granted to those who perform criminal investigation duties. Federal IG criminal investigators receive statutory law enforcement powers through the enactment of the Homeland Security Act of 2002. Section 812 of this law statutorily provided federal IG criminal investigators with the authority to carry a firearm while engaged in official duties, make an arrest without a warrant while engaged in official duties if the criminal investigator has reasonable grounds to believe the person to be arrested has committed or is committing such a felony, and upon probable cause to believe that a violation has been committed, seek and execute warrants for arrest, conduct a search of premises, or seizure of evidence. To ensure the proper exercise of law enforcement powers, the law also required federal IGs to undergo peer reviews to assess the adequacy of internal safeguards and management procedures. Because the DC OIG statutory framework was modeled after the Federal Inspector General Act of 1978, and we are bound by standards promulgated by the federal OIG community, we are required to undergo similar triennial assessments to assess the adequacy of our law enforcement safeguards and management procedures. At the state level, OIG criminal investigators also find their law enforcement powers conferred via statute. For example, the Virginia Office of the State Inspector General Investigations Unit staff, as designated by the State Inspector General, have the same powers as a sheriff or law enforcement officer in the investigation of allegations of criminal behavior affecting the operations of a state agency. Similarly, in Indiana, Inspector General investigators have been included within the definition of a law enforcement officer. Finally, at the local level, we see statutory law enforcement powers conferred to various district investigative agencies. For example, designated DC Fire Emergency Medical Service arson investigators have the same general police powers, including arrest powers, as regular members of the Metropolitan Police Department for the express purpose of enforcing the fire safety laws in effect in the District of Columbia. Similarly, Office of Tax and Revenue employees who conduct investigations of alleged misdemeanor and felony violations have the authority to carry a firearm inside or outside of the District of Columbia in conformance with state and local laws, and make an arrest without a warrant if the employee has probable cause to believe that a felony violation of a federal or District of Columbia statute is being committed in his or her presence within the District of Columbia or subject to state and local laws outside of the District of Columbia. In the above examples, the statutory authorities empower the respective criminal investigators to execute their statutory investigative mandate. I note that our research found no other investigative agency similarly mandated as the DC OIG that does not possess the requisite authority to perform their assigned responsibilities. As codified, the OIG's investigative mandate is to independently conduct and supervise investigations relating to the programs and operations of district government departments and agencies, including independent agencies. The OIG's investigative mandate also includes investigating alleged violations of Medicaid provider fraud, the misuse of Medicaid patient funds, and the criminal abuse, neglect, and exploitation of persons residing in Medicaid-funded healthcare facilities. Once an OIG criminal investigation has established reasonable grounds to believe there has been a violation of district or federal law, we are required by law to report such violations to the U.S. Attorney General. This reporting often occurs with our partners at the United States Attorney's Office for the District of Columbia. Examples of the violations investigated by OIG criminal investigators include bribery of public officials and witnesses, embezzlement of public money, property or records, false statements, wire fraud, theft or bribery concerning programs receiving federal funds, healthcare fraud, criminal abuse of vulnerable adult or elderly person, and financial exploitation of a vulnerable adult or elderly person. There is no other district entity charged with investigating these types of criminal violations against district programs, operations, and residents. It is important to note that the OIG's criminal investigative mandate does not include typical police functions like conducting patrols and engaging with the public in response to emergency calls. This mission is the exclusive province of MPD. Generally, OIG criminal investigators will only encounter the public during pre-planned investigative activities. Based on our research and confirmed by the OIG, we have concluded that the OIG's current authorities limit OIG criminal investigators' ability to execute the full spectrum of required investigative tasks. The inability to conduct certain investigative tasks impedes the OIG's ability to meet its statutory criminal investigation mandate. Simply put, DC Code does not allow us to do what DC Code requires us to do. At present, in order to execute our criminal investigative mandate, OIG criminal investigators are empowered with the authorities to carry firearms in the District of Columbia or a District of Columbia government facility located outside of the district, execute a warrant for the search of premises or the seizure of evidence if the warrant is issued under authority of the District of Columbia or of the United States upon probable cause, and make arrests without a warrant if the employee has probable cause to believe that a felony violation is being committed in his or her presence and the employee is engaged in the performance of his or her official duties within the District of Columbia or a district government facility located outside the district. These authorities, which set the boundaries within which OIG criminal investigators may act, place specific limitations that adversely impact our ability to execute certain investigative tasks. Further, without the statutory declaration of OIG criminal investigators as law enforcement officers, we are further restricted from executing additional investigative tasks. As a result, the OIG remains responsible for independently investigating allegations of criminal misconduct without the authority to do so. Specific conditions that contribute to the gap between our criminal investigative legislative mandate and our criminal investigation legal authority include the ambiguity of OIG criminal investigators being mandated to perform a law enforcement function, yet lacking statutory designation as a law enforcement officer. Other district employees, such as animal control officers and arson investigators, are statutorily defined as law enforcement officers. Ostensibly, these district employees' investigative mandate is much narrower than the OIG's, yet their classification as law enforcement officer provides them the requisite authorities to execute their investigations unencumbered and unreliant on other law enforcement partners. Armed OIG criminal investigators, when operating in other jurisdictions, for example, to conduct interviews, potentially place themselves in legal jeopardy if they are not recognized as statutorily designated law enforcement officers. OIG criminal investigators are required by statute to be trained law enforcement officers and specifically undergo training that includes the safe handling of firearms and the use of deadly force, and are required to qualify on their firearms according to standards promulgated by MPD. Further, all OIG use of force incidents are investigated by MPD's Internal Affairs Bureau. OIG criminal investigators are provided the statutory authority to seek and execute a search warrant. However, both Federal Rule of Criminal Procedure and Superior Court Criminal Rule 41 require an application from a law enforcement officer or attorney for the government to request a search warrant. Without OIG criminal investigators being statutorily defined as a law enforcement officer, they are unqualified under both the federal rule and the Superior Court rule to do what DC Code authorizes them to do. This gap introduces considerable risk to the district and OIG criminal investigators. Unless the gap is eliminated, OIG criminal investigators risk being considered a private citizen while executing their investigative responsibilities. An inability to execute probable cause arrest warrants. Currently, OIG criminal investigators may make an arrest without a warrant if they have probable cause to believe that a felony is being committed in their presence while on duty within a district or in a district facility located outside the district. However, OIG criminal investigators are not permitted to execute an arrest pursuant to a judge's issuance of an arrest warrant or grand jury indictment. At present, OIG criminal investigators' ability to make an arrest is comparable to that of a private person, except the private person arguably has even greater authority, as they may make arrests with probable cause for felonies and misdemeanors that are enumerated in the DC Code and committed in their presence. An inability to exercise the full use of force continuum. OIG criminal investigators are statutorily mandated to be trained law enforcement officers as a condition of employment. Additionally, they receive continual training in the use of force and defensive tactics, and they carry firearms in the course of their official duties. However, the OIG has opined that the DC OIG statute does not authorize OIG investigators to carry and use less than lethal weapons, such as OC spray and batons, in the performance of their duties. Limitations on the OIG criminal investigators' ability to use less than lethal force to de-escalate a situation introduces considerable risk of a non-proportional response given the threat. A non-proportional response could introduce civil liability to the district and criminal and civil liability to the OIG criminal investigator. The OAG has also opined that the geographic restriction found in the OIG's enabling statute related to the carriage of firearms has been preempted by the Law Enforcement Officers Safety Act of 2004. However, should an OIG criminal investigator use their firearm in the course of their official duties outside of the district, significant risks remain about whether the jurisdiction would treat them as law enforcement officers or private citizens. An inability to directly enter into agreements with federal, state, or local law enforcement agencies. For example, the OIG does not have the authority to enter into agreements and participate in regional task forces, such as the Department of Justice's Healthcare Fraud Strike Force. As such, the OIG is unable to benefit from the synergies created amongst various entities that share a common goal of addressing corruption, fraud, and patient abuse, neglect, and financial exploitation. Further, absent the ability to enter into these agreements, the OIG is unable to ensure the district's equities and values are effectuated when conducting joint investigations, essentially leaving the district's interests in federal hands. Finally, OIG criminal investigators are not afforded the status and protections commensurate with the scope and risks inherent to their job. An individual who seeks to harm an OIG criminal investigator as they execute their statutory mission may not be held to the same legal standard as if they harmed other law enforcement officers. As we have demonstrated, criminal investigations are inherently risky because they seek to determine whether an individual's actions put their liberty at risk. The gaps that exist between the OIG's statutory mission and the limitations I have just discussed pose untenable risks to OIG criminal investigators' personal safety, expose OIG criminal investigators to unnecessary criminal and civil liability in the performance of their official duties, and pose a risk to the district. The OIG is unable to execute the continuum of investigative tasks and is reliant on our law enforcement partners to execute our statutory responsibility and assume these risks. Going forward, the successful criminal investigation outcomes the OIG has previously brought to the district will be reduced considerably or eliminated if there is no interest from another law enforcement partner to assume responsibility, which could leave no viable path to complete an investigation. The OIG has experienced considerable success over the past years despite the gap. In instances where we have been unable to execute certain investigative tasks, we have sought the support of our partner agencies. Thankfully, given the robust partnerships we have built up, our partners have been willing to execute these tasks and bear the corresponding risks and liabilities. Changes in resource allocation or priorities within our partner agencies will delay or put completion of our investigations at risk. Finally, while we have been successful in conducting criminal investigations, we also have been fortunate to not have a use of force incident or allegation of violations of an individual's constitutional rights. Given the inherent risks to conducting criminal investigations, it is not a matter of if, but when our authorities become the subject of litigation. Should the OIG's legal authorities be challenged, I want to ensure the district government and the OIG's criminal investigators are on the soundest legal footing, so there is no ambiguity regarding the scope and limitations in carrying out the OIG's mission to conduct criminal investigations. As Inspector General, I do not have the authority to mitigate these risks and fill the current gap that exists between our statutory mandate and statutory authorities. The legislation we have before the committee today is the only avenue to ensure we can do what this body has mandated us to do. In conclusion, Chairperson White and members of the committee, the solutions found in Bill 24-0129 will help close the gap that currently exists between our criminal investigation legislative mandate and our criminal investigation legal authority. The gap has existed since the addition of the OIG's criminal investigation mission and corresponding authorities. It is clear that the previous legislative revisions called for an OIG that could independently execute criminal investigations related to the district's programs and operations. Once enacted, this bill will help reduce risks that result in significant government liability, impact the personal safety of OIG criminal investigators, and subject OIG criminal investigators to criminal and civil liability. It will also ensure the success of the OIG in the future, reducing the need for handshake agreements between our office and our partners. I can assure both you and the public watching at home that this legislation does not increase the law enforcement footprint within the district. This legislation simply confers the authority on our criminal investigations that is commensurate with their investigative responsibilities. On the contrary, armed with these legislative improvements, the OIG will be better positioned to lead its investigative work and reduce the reliance and corresponding presence of outside law enforcement entities. In summary, OIG criminal investigators need to be able to safely and proportionally defend themselves and others, ensure the public's constitutional rights are protected, and ensure that evidence gathered during an investigation is admissible in a court of law. As it currently stands today, the OIG does not have the requisite authorities to independently execute its criminal investigative mission. It is my responsibility to ensure OIG criminal investigators have the legal authority to perform their investigation duties. Where I find the law does not support an action, I will not ask my investigators to assume personal risk or risk to the district. I will leave you with one last comment. Prior to the establishment of the OIG's criminal investigative mission, public integrity investigations were conducted by MPD, which was armed with the requisite authorities to meet its investigative mission. My team and I look forward to working with you and the committee to advance this legislation. This concludes my testimony, and I'll be happy to answer your questions.
Thank you, General Lucas. So let me start just by making sure I fully understand the exact authorities that you are requesting. So a certain part of this is simply a designation as law enforcement. Is that right?
That's correct.
Okay. And the designation of law enforcement will do what specifically?
The designation will make sure that as they're doing their jobs, they are recognized and hold the authority and hold legal authority as law enforcement officers. For example, if we're conducting an interview in Maryland and our authority is questioned, we cannot tell anyone that's questioning us we're a law enforcement officer, and they may not respect that we have a criminal investigation mission. And if something should go wrong, the investigator may be treated as a private citizen, although they are performing the criminal investigative mission for the District of Columbia.
Can you be more specific? So for someone who doesn't do this work day to day, how might that play out in a real or hypothetical scenario? Okay.
I would say that taking the Maryland example further, if they've gone out to perhaps do a witness interview to move a criminal investigation along. And if something should go wrong where they have to protect themselves and then perhaps are accused of assault or something of that nature, responding law enforcement officers may not recognize the agent as a law enforcement officer with the authority to do the interview and to protect themselves in the process.
There are some statutes, I don't know what they are offhand, but I know they've been a matter of discussion in the past, but the statutes that protect law enforcement officers in certain instances and capacities. What are some ways that a law enforcement designation would extend to OIG? I know you mentioned one piece in your testimony, if there is, I think, an assault on an assistant inspector general. What are other ways that federal or local laws may, or your agency and employees would be impacted by this designation?
I'm not sure I'm following your question.
So there is a, you mentioned in your testimony, there's a heightened penalty if you assault a law enforcement officer than if you insult probably a council member. But I guess I don't know if there are other things like that we don't necessarily see right now.
Ben, can you think of anything else?
Chairman White, I would try to answer you the question on that. During my time as can you hear me?
Yes.
Okay. During my time as a federal agent in the field and even at Amtrak, when you're operating outside the district to conduct interviews or any type of operation, you have to have the designation as a law enforcement officer. Otherwise, you will not be received or treated by outside jurisdiction as you could be treated as a potential imposter, so to speak. And under my watch, when I was at Amtrak, we actually had that to happen with an agent who was attempting to go out to do an interview and was confronted by local law enforcement because the person questioned whether or not this person was in fact the person who he said he was and with the credentials that he had. We were able to show and to demonstrate that he was in fact a designated law enforcement officer. So from that perspective, if our agents are out operating in another jurisdiction, most often that's part of some type of grand jury investigation. And so as a result of that, then there's some protections for assault against law enforcement officers in the performance of their duty in the carrying out of an investigation that is pursuant to the United States Attorney's Office that has been presented, a case that has been presented to the United States Attorney's Office. So there are some protection there as a result, as it relates to federal protections, as well as any state and local charges that might come about as a result of assaulting an officer in the performance of his or her duties.
Thank you for that.
Does that answer?
So, yes. So I want to continue kind of making sure we understand exactly what changes you envision. One of the other examples you mentioned are search warrants. Talk to me about how search warrants are handled now and how they would be handled if this bill were to pass.
Okay, how they're handled now, today, we don't have the authority to apply for a search warrant because we lack that designation. If we need a search warrant and we just happen to be working with a partner, a federal partner, they would take on that responsibility. If we are not working with a federal partner, we may just simply be barred from applying for the warrant.
And use of firearms, I've continued to get a little confused on the ability to carry firearms in and outside of the district now, and with the provisions of the bill. So right now, you can carry firearms in the district and district-owned properties outside of the district. Is that
okay? All right. So this is kind of sort of how that situation has evolved. Originally, we were permitted to carry firearms within the district and within a district-owned facility outside of the district. No more, nothing more than that. But in 2004, I think it is, the Law Enforcement Safety Act preempted that restriction, and it allowed law enforcement officers to carry a concealed weapon across boundaries. So we fell into the definition of law enforcement officer for that particular statute. But what isn't clear is, while we are outside of the district performing our duty, if, God forbid, we have to discharge a firearm, will we receive protections as law enforcement officers? That has not been tested. Okay. I'm trying to, after evaluating the risk, I'm trying to mitigate that risk, rather than wait for it to happen and then come and say, I need additional authority.
So, okay. And you cannot, even in the district, carry less lethal weapons?
Correct. That is what OAG opined, that there is no permission for us to do so, therefore we cannot.
Okay. You mentioned OC spray. What is OC spray?
It's similar to pepper spray.
Okay.
It's an irritant, meant to disarm someone using less lethal force.
Okay. I believe the U.S. Park Police and the WMATA police have citywide jurisdiction. I don't remember offhand whether other law enforcement bodies in the district have kind of broader jurisdiction or authorities. Would anything in this bill extend the current work or jurisdiction of Metro Transit Police to OIG employees?
No, and not that as I understand your question, no.
Okay, so if you saw someone speeding, there's nothing in this bill that would give authority to OIG to pull that person over or arrest them?
No, that's not the job we've been given to do. No.
Okay. And these authorities can't be done by a mayor's order?
I don't think so. Right, because it is a statutory designation that will in turn be respected beyond the district. The mayor's order may not.
Okay. And the OAG opinions that you referenced in your testimony, can you share those opinions with the committee, or have OAG do opinions on these matters so that we can review the legal conclusions?
Yeah, absolutely. I'll work with the OAG and your office to make sure you have that information.
Thank you. So someone might say, all right, I've listened to the testimony and the concerns, and these are only hypothetical at this point. It's not necessary. to make these statutory changes. What would be your response to that concern?
My response would be inherent in the job is risk. As the leader of this organization, it is also my responsibility to understand that risk and do everything in my power to mitigate that risk. I don't have the authority to transfer this risk anywhere else or assume it for the District of Columbia. As a leader, I come from the school of thought. Don't wait for a problem to occur when you know the potential exists. If you have it within your span of authority, you must mitigate it. If you do not, you must communicate that to your superiors for them to mitigate.
And I'm sorry, I skipped over this a minute ago. Arrest authorities. Can you talk about your current arrest authorities and how those would change with this legislation?
Sure. Currently, our arrest authority is only if we are witnessing a crime being committed in our presence in the District of Columbia or district-owned facility while the agent is performing their duties. Can we arrest someone? What the legislation confers upon us, the ability to apply for upon probable cause to make an arrest and not be reliant on any external parties to do so if the need arises.
What are the and you mentioned this in your testimony, so I apologize for asking you to repeat it. But what crimes is your office responsible for investigating?
My office is responsible for investigating any crime related to the programs and operations of the District of Columbia: embezzlement, bribery, fraud, abuse of individuals on Medicaid, theft of government property. It's a long list of offenses that we are responsible for. And I can share with you, in my tenure, we have probably investigated many of those crimes that are under our jurisdiction.
And I would assume that you don't have exclusive jurisdiction over any of these. Is that right?
Actually, for the most within the district, for district programs, we do. However, the federal government, namely the FBI, may also take an interest in an investigation. At that point, we will share responsibility to investigate that crime.
Okay. So let's say you are investigating embezzlement by a DC government employee. That would be under your jurisdiction?
That is under my jurisdiction. And
right.
We just had a case back in 2019, just before the pandemic, where we investigated that exact crime.
Yeah, I saw actually some updates from your office on that, and I appreciate you sharing those updates. So in a situation like that, what is your current statutory authority to make an arrest?
It's as I described it. In that particular case, we did not execute the arrest warrant. We were part of the search warrant, but we could have been part of the arrest, but we didn't have the authority to do so. We had to defer to a federal entity.
And so if it was a bribery case, if you saw someone handing a bribe, you could arrest them currently?
If they are committing the crime in our presence while on duty in the District of Columbia, yes.
Okay. And when you arrest someone, or if this legislation were to pass and you arrested them, where would you transport them to?
To the detention center.
Okay. At the bottom of page 12 of your testimony, you mentioned difficulty or inability to enter into agreements with federal, state, and local law enforcement. What kind of agreements are you referencing there?
Most notably, when a task force is stood up to pursue a persistent crime, and they bring together different law enforcement entities under the umbrella of a task force. Usually, in order to participate in that task force, you enter into an agreement with the leader of that task force so that each entity understands the scope and limitations of things that will or will not occur.
Okay.
Most notably with our Medicaid fraud control unit, they do something almost every year called a strike force. That's where they bring all resources that are involved in the investigation of abuses against the Medicaid program and attack it all at one time. We can't participate in that. We can only participate from the sidelines while our partners go and conduct that activity. Now, mind you, many of these cases are our cases that we investigated. So when they execute the strike force, they're going to arrest people that were the result of our work. Months and sometimes years of work that we put in. But when the task force strikes, we're on the sidelines.
What
LeVan,
what number?
Anything? Are you good?
I'd just like to add to what the Inspector General has stated, and going back to a question you raised earlier. Without the passage of this legislation, we are virtually sidelined with respect to carrying out our duties as law enforcement criminal investigators. We will be performing a secondary, if not just a support role in any type of investigation, including our Medicaid fraud-related investigations. As it stands right now, I will speak for the Medicaid program, our federal partners rely 100% for us to be the experts with respect to determining which investigations we should engage federal resources and invite them in to participate. And I said the word invite. They do not come in to participate without us making some assessment of the particular matter that's under review. Without having this being a full-fledged partner at the table, then we have no role to participate whatsoever. And we bring no value to them with respect to the Medicaid fraud control unit. There is an enormous amount of money that comes into the district as it relates to healthcare through the Medicaid program and through other programs. And so this is a very, very important program for us to have, and that we need this authority to carry out our duties.
Okay. What number or percentage of state IGs have the same or very similar law enforcement authority?
Question again?
What number or percentage of state inspectors general have law enforcement authority?
The numbers, I can't quote you the numbers, but what we do know is if they have the responsibility to conduct criminal investigations, we haven't found a single one that didn't have the authority they needed to conduct their investigations.
Okay.
Which is why, when this whole thing, kind of, bubbled up really a couple of years ago, our partners were actually surprised, that we didn't have, the tools that other IGs had when they were working with other IGs.
Well, I guess that makes me wonder kind of what number of percentage of IGs do or do not have criminal authorities.
Sure, I can try and prepare that information for you. I believe we do have some of that information in house, so we can quickly provide you that information.
Perfect. I appreciate that. And elaborate on why it's a problem. So someone might say, all right, if you conduct the investigation and when it's time for an arrest, you partner with MPD or other local law enforcement. Why is that a problem?
It creates an independence problem because we are the Office of Inspector General. We're responsible to provide oversight of pretty much, all of district government. And so if I'm asking another agency to do something that I've been tasked to do, and in some instances, I'm investigating individuals within that agency, it creates a conflict. As well as, we have MOUs with MPD about making sure they understand that they are under our investigative authority under, certain crimes. So we don't like to be able, we don't like having to rely on an entity that we have to provide oversight of. As a matter of fact, a few years ago, there was some issues with a chief of police and a staff member who fell under criminal investigation because they were doing a number of things that weren't legal. We don't want to find ourselves in a similar situation. Secondly, it transfers risks, that are inherent to the OIG onto another entity. So we would then also be subject to their priorities. Something that may be an immediate need for us may not be a priority for that entity, which is why the legislation, it provides the integrity that we need for the mission itself, so we don't have to rely, on other entities or worry about conflicts or someone else's priority or transferring a risk that they're not willing to accept.
We have discussed this, so I know the answer, but if you would talk about partnership with federal authorities and the limitations there. I know you had mentioned to me that they are generally hesitant to get involved if there's not a federal nexus.
Correct.
Can you discuss that?
Correct. There have been instances where we are investigating a crime that's only of interest to the District of Columbia. It's a bona fide case dealing with district resources, district programs, that is, and we are the only ones, in the district who can or who will investigate it. We've had instances where we meet with the FBI and say, hey, we've got this case, this thing and that thing is going to happen. Are you in? The answer is no, that's, district business, you go ahead and take care of that. Now, of course, what that does, it implicates all of the gaps between our mandate and our authority. So the investigation itself could mature to a point where, let's say, we need a search warrant. Because we're not designated law enforcement, we can't apply for that search warrant. Or, if we find ourselves needing to arrest someone, okay, the options that are left to us is to perhaps talk to MPD and convince them that this is what we need, share the evidence with them, and then they have to make a judgment on whether or not, you know, they want to engage in that activity.
And how many criminal investigators does OIG currently have that would be impacted by this bill?
Roughly 31 plus.
Somewhere right around 30, because you're talking about the agents and their supervisors.
Okay. Do you happen to know if prosecutors in DC have law enforcement authority? I don't know why you would know that, but
I'm going to let Karen answer that question.
They're all DOJ employees, so yes.
okay, thank you. How do you train your criminal investigators? And you're on mute, General Lucas.
Sure. How do we train our criminal investigators? All of our criminal investigators are required to have completed a course of instruction to conduct criminal investigations. The premier training for that is at the Federal Law Enforcement Training Center. So if we get an agent in, the first thing we do is validate that they have in fact been through a course of instruction. When they arrive, they then are subject to quarterly in-house training by some of our in-house instructors, as well as DOJ instructors, as well as other federal OIG instructors on the use of force, firearms, any type of scenario that they may encounter. Throughout the year, they meet at least 4 times to conduct that type of training. In addition to twice a year, they qualify on their firearm using the MPD standard.
And what about, can you say more about use of force training?
Levan, you want to talk about the program you set up?
Yes. So with the use of force training, we actually go into, we receive both in classroom training as well as we go out and we actually go through physical instruction on terms of applying use of force training. That's each individual officer, agent is then shown how to apply use of force training. And to the Inspector General's point, we've gone through that training. It's required by SIGI standards in the enforcement, and those are the standards for all criminal investigators, for all federal criminal investigators, and those are the standards by which we operate under as well.
Okay, I appreciate that. And I guess to add some clarity on the reason I asked about prosecutors, my very first job out of law school was clerking for a court in Montgomery County, where I learned, to my surprise, that prosecutors could carry firearms. And so, it dawned on me today that they may have some, if not exactly this type of law enforcement authority, but without the type of training that your assistant IGs or IG investigators would have. And, as you know, General Lucas, and I should clarify, I don't have an interest in creating more law enforcement or a new kind of police force, but this bill may be more in line with, and I think it is, but I just have to continue to dissect it, more in line with authorities than kind of law enforcement. So you already can carry firearms, but there are other things like these search warrants, like these agreements that are, you argue, and you may be right here, necessary to carry out the statutory duties. How many criminal cases does the OIG investigate in an average year?
in an average year, Levan, how many do you have on the board?
Right now, we have roughly about 90 cases that are open.
And we probably have an equal number in our investigations unit. So at any one time, you're looking at, somewhere around 200 cases that we're pursuing.
Okay. And what, other than MPD, well, I think you mentioned some of these, but I don't know if it's the universe of them. Other than MPD, what other local agencies employ formally designated law enforcement officers?
Sure. UDC police, special police officers, for example, at the public library, DC Protective Services, Department of Corrections, court services and offender supervision agencies, animal control officers, fire and arson investigators, tax agents, all have, the authority that's commensurate with the job that they're required to do. And what I might add, Chairperson White, is what we're asking for, if you go back and look at, the legislative, record, what we're asking for was contemplated back then, and we can see in the record, where legislators were saying, we need to make sure that the OIG is able to do this. We need to make sure if we're going to give the OIG the authority to arrest someone, we got to make sure they have the right vehicles, and so on and so forth. So the point I'm trying to make here is that for my purposes, we're just simply trying to correct what we believe is in oversight in the legislation.
All right. Please.
Because as I hope I've demonstrated to you, the things we are asking for are nothing more, nothing less than we need to do the job and what others already have who do a similar job. So we're not asking for you to make us super, criminal investigators. We're just asking you to give us the tools to be a criminal investigator.
If you haven't already, if you could share with the committee team that's that legislative record.
Sure.
Thank you. And what kinds of law enforcement authority does or do federal IGs have?
Federal IGs have everything that we're asking for, the exact same tools to do that job in a federal context. We're asking for similar tools to do here in our local context.
And have there been specific cases that your office has been unable to pursue because of the lack of authority? Sure.
I can share with you one of our most, a case from 2019. It was a case of a multi-million-dollar fraud committed by two individuals who were essentially running separate schemes in an agency. So we got the case, quickly did the analysis of the data, identified who the wrongdoers were. We knew we had to bring in the FBI because we couldn't execute the search warrant nor do any arrests. So when it came time to execute the search warrant, and this was actually a case that I had asked my criminal investigator leadership if I could shadow them on, because I wanted to really understand, their concerns about, what happens in the job that they do. So I was present, during the execution of the search warrant. I wasn't really present. I was way down the road until everything was secured. But when it was clear for me to observe them do their work, They were in the process of conducting interviews. Well, actually, let me take a step back. When the initial warrant was executed, we had folks, kind of running, and we later found out that they had drugs in the home that they were selling. We also found automatic weapons. And it was at that moment that, in talking with my team, the conversation was, if we had the ability to make that arrest, we would have arrested the individuals because of the firearms and the drugs. But because the FBI had no interest in that local issue, there was no arrest. So that's just an example of the types of investigations that we pursue and how we hit some of these roadblocks in the execution.
And how can the public be assured that OIG won't become effectively an additional police force with these authorities?
We have a very specific mandate, and it is simply to conduct criminal investigations against the programs and operations of the District of Columbia. We are not policing anything. We go through a very, very meticulous process and perform specific tasks at specific times that in many instances, the public doesn't even know about until there is a public pronouncement of an arrest, indictment, or something to that effect. So essentially, it will almost be no different than what they experience right now. But what they will know is that they can be confident that the agency has everything it needs to protect their resources and not have to invite federal entities into the District of Columbia to do that for us.
And one of the things, and I think this is specifically laid out in the bill, would be the ability to form federal or interjurisdictional partnerships without the approval of the mayor or the council. Talk about why that's important.
Why that's important is oftentimes during the course of our investigations, we may need something that a partner has. Some piece of surveillance equipment or a particular resource. In order to do that, we often have to enter into MOUs. So there's understanding from each party how things are to happen. It's really, a benign thing. It's mostly to make sure that the district's equities in a lot of instances are represented, and to make sure if there's an opportunity for us to get a particular resource that we really need to carry out a task, we can quickly do that. As opposed to sending over a memo to someone to say, we need to do this thing that we really don't want you to know about. Can we do it? So a lot of times it's to protect the sanctity of what we're doing, to be able to get resources that we need, and also to be able to protect the district's equities, when these things occur.
Why not limit that more to say that you have this independent authority, sort of when necessary?
And I'm completely okay with that. One thing you'll know about me, Chairperson White, I don't want anything that I don't need. I don't want anything that's going to cause my agency or the district problems. But I do want the things that will enable me to do the best for the district.
I appreciate that. And for my part, I have a great deal of respect for you and the entire agency. I don't know who's coming behind you or three people behind you. And so, I always try to make sure we shape these things not based on the person sitting in the seat, but as you said, what's in the best interest of
Right.
the district.
And I'm actually glad that you point that out, Chairperson, because the things that we're asking for actually really bring the boundaries into clear focus. Okay, the boundaries that this creates, I'll be subject to them. The individual that comes behind me will be subject to him. There will be no ambiguity. So that if something goes awry, there can be proper oversight without trying to sift through, well, I think it says that, maybe it doesn't. So this actually gives us more boundaries, and it would corral the potential wayward, IG, if you will.
So on the issue of oversight, if the council expanded OIG's law enforcement authority, would you be concerned about having your criminal investigators be subject to the Office of Police Complaints?
I'm never concerned about oversight, as long as it's appropriate. If OPC is the body that polices law enforcement, I have no issue with that. But you have to also understand we have oversight by a number of folks, including yourself. I think oversight is good as long as it's the right oversight.
Okay. And what about public use of force reporting? Would you have concerns with that attaching?
None whatsoever. None whatsoever. I believe in order for anything to be as strong as it needs to be, you have to have oversight, you have to have procedures, you have to have training. That's the only way you can have any system strength and integrity. You cannot have a program that does not have oversight, because you do end up having rogue things happen. And I'm not interested in that. That's just not me. And if we put these boundaries in place, the oversight can be very precise.
Oh, obviously, one of the tools, I guess you could call it a public oversight tool that we have been pushing for years in the district, is use of body-worn cameras. I don't immediately know how that would apply here, but would you have concerns with, and do you think it's feasible to deploy body-worn cameras to criminal investigators?
I haven't yet discussed this with my investigations leadership, but I do believe there are activities that we would engage in where a body-worn camera would be appropriate. Because not only does it protect the individual, it would also protect the agents in their actions. So not to get ahead of my leadership team, I would have no issue with that.
Okay, and I do understand that we would work with you on it to understand kind of your more formal position. One concern I do have is about partnerships that might be formed with federal immigration agencies that might impact our sanctuary cities policy. Could we specifically prohibit partnerships with federal immigration agencies in the bill to avoid that problem?
And so that's why, the ability to make sure we have that MOU is in place, because I'm still bound by the policies of the District of Columbia. Just because a federal entity, wants to do something, I'll be at the table to make sure our equities are represented. And if it's the policy of the District of Columbia that those sanctuary cities are protected, then I can represent that, with our partners.
If we move forward with this bill, that's something that I would want to work through with your office and OAG, just because I don't know how your status as an independent agency is impacted by these types of federal partnerships. And again, not knowing who's coming later, we would want to make sure that's clear. appropriately as possible. Those are all the excuse me, questions that I have for now. I guess one thing I want to clarify for the record and how we are analyzing this, other than the kind of broader law enforcement issues that we mentioned earlier, the concern with creating a new police force. The argument that I'm hearing from you is this is not law enforcement authority to do policing, but law enforcement to protect the district government and taxpayers, district resources, to make sure that your agency has the ability to do those things, and really nothing more than that.
That is absolutely correct, Chairperson.
Okay. Well, those are all the questions that I have. Is there anything that we've missed that you think is important to cover, General Lucas?
No, just that, I want to thank you for taking this on. I think it's very, very important for the district, and I think you share that, or else you would not be holding this hearing. And it just finally, what I'll say, and it just summarizes, what you just said. The Inspector General, this office is only seeking the tools that it needs to do the job properly.
I appreciate that. Well, I want to thank you, General Lucas, Ms. Branson, Mr. Griffith, for being with us today. And General Lucas, I know I'll see you again in about an hour for another hearing. So I appreciate that. And I'll say thank you in advance. Let me apologize again for our delay in getting started. It was unavoidable in budget season, but did not mean to leave you waiting. But again, want to thank you for being with us. I want to say to the public, for anyone who was unable to testify, written testimony is encouraged and will be made part of the official record. If you are interested in submitting testimony, you can do so by email. Send it to the Committee on Government Operations and Facilities at facilities@dccouncil.us. The record for this roundtable will close at the close of business on Wednesday, July 28th, 2021. The business before this committee is concluded. The time is now 1:56 p.m. and this roundtable is adjourned. The committee will reconvene in our public oversight roundtable at 3 p.m. this afternoon using a separate Zoom link sent for that roundtable. So thank you all again, and thanks to the public.